I think we need to kick off officially. So good afternoon and a very warm welcome to all the familiar faces, as well as to all the new attendees. I see a few very familiar names: Ingrid Klutter, Lorraine Jacobs. I know Stuart Alexander, he registered. We've got other podiatrists as well. Megan, Erin, welcome to you. And then there's also a lot of leaders in the association, some society, and from the HPCSA. Welcome to each and every one of you. Now, my name is Lani Uys, and as you know, I'm a product manager at the SpaceNet Global Group, and I'll be your host this afternoon. This is our 7th of our series of webinars, and it's been going really, really well. We've been speaking about how to navigate telehealth, how to future-proof your practice. We've done practical demonstrations of the integration between EZMed, your practice management application, as well as Medici, a telehealth platform. We've addressed desks, dress, the do's and the don'ts, and also how to build patient trust when you're doing and practicing telehealth. And then last week we started on this ethical course, and we had part 1 of our ethical billing in practice. And I think it was sort of what's the word I'm looking for? It reached so much enthusiasm that we thought there needs to be a part 2. So you will definitely recognize the two faces on the screen. It's our guest speakers from last week as well. We've got Deon here, who's, as you know, the director of ProfNet Medical. Pardon me. And then we've also got Neil Hopkins. Now, Neil is currently in private practice in Cape Town. He's a biokineticist himself. Neil is lecturing at UCT, ethics on business management, that sort of thing. Neil hates it when I'm talking about his bio, but I'm going to carry on. Neil has been on BASA, on the association, and represented it both on a regional and a national level, and also on the HPCSA, on the PPB board and committees there. And currently he's completing his master's degree in bioethics and health law at the Wits University. So gentlemen, very welcome to you both.
Thank you very much, Lani. Hello, Neil.
Guys, just a reminder that all the webinars are recorded, and a link will be made available to the webinars, to all the question and answer documents, and any other associated documents as well. All of these you can find under the webinar tab, under the EZMed.solutions website, and you can find that name on one of the screens there on the webinar. I want to share a quick disclaimer with you before we carry on, and I just need to share my screen. So if you don't mind just giving me 1 minute. Deon, can you maybe just indicate that you can see that?
Not as yet.
Not yet. Let me try that again. Anything now?
Nope.
Nope.
Just for Cornelia, where can you find the recording of the previous webinar? It is on YouTube, so you can find it there.
And then also the links are on the EZMed.solutions website. And if you go to the webinars tab, you'll actually see the upcoming ones you can register for next week. We've got some exciting news on that one. And then also the past webinars, and you'll find the links to the recordings there.
Absolutely. Guys, it doesn't seem as if the screen sharing is working, but I do just want to read something to you. And this is just a disclaimer with regards to the question and answer document. We've also got very, very interesting guests with us every week, Thursday afternoon. And all the questions and answers that is sort of documented are answered in their best possible way according to the current rules and the regulations. So just a quick disclaimer, I am going to read this to you. I do apologize for that, but please note the questions and the answers that are following on these documents, and that is based on the discussions held in the webinars. They do not serve or substitute for consultation with professional accounting, tax, legal, or other competent advisors. The application and impact of laws can vary widely based on the specific facts involved, and given the dynamic and the changing nature of laws, rules, and regulations, there may be delays, omissions, or inaccuracies in the information contained within those documents. The material available in the Q&A is designed to provide general information only, whilst every effort has been made to ensure that the information provided is accurate. The authors and the publishers are not here and engaged in rendering legal, accounting, tax, or other professional advice and services. So for a legal position on any of these discussions, and before making any decision or taking any action, please be sure to consult with the relevant professional advisors to advise you on your specific requirements and challenges. So please just note that. Deon and Neil both just asked me to convey that message to you. So yes, today we are busy with part 2 of ethical billing in practice. And just a reminder that this session is brought to you again by the SpaceNet Global Group with the support of EZMed and Medici. And we were lucky enough to secure one ethical CEU point for you today. And we got that with the help of our Academy of Learning called DAXA. So without further ado, I think Deon, Neil, this is going to be a nice, very interesting discussion. We had so many questions from last week's webinar that actually stood over that I actually want to kick off with one of them. And I'm going to try and merge a couple of the questions. And a lot of them came in with regards to medical aids, medical schemes, the ethical aspects behind that, but also with regards to patient information and confidentiality. And I think that's probably a good place to start. Now, gents, I'm not sure who wants to start. Where do you want to go from here? John, you've got your hand up.
That up to me is that you starting.
Neil, if I may, because I think I've had a few people call me and actually have a direct conversation around this since our discussions last Thursday. And good afternoon to everybody, and thanks, Lani, again for the introductions. And I think I just want to give a broad principle on that, and maybe just reiterate some of the points I made last week. And then Neil, I know you've got all the legal points at your fingertips, and I think you'll give us that view, which I think is most important. But Lani, as far as the question that came up last week is if a medical scheme asks me for the patient notes. For copy of my clinical notes is often how they'll say it.
Yep.
What is my position? Should I just be giving those across? Are they my notes? Do they belong to the patient? And you know, my position is most certainly one, as a clinician myself, is if that question was asked to me, I would definitely pause and think about that, apply my mind, do the research, and make sure that I don't just hand those across. And I think that's the most important thing, is just pause before you do that. The debate does go down the lines of, but is it the patient's notes or is it the clinician's notes? Who do they belong to? And if we really have to separate those two off, obviously within your notes, there is patient information, the patient's name and surname. Where do they stay? What is their complaint? What is their medical history? Those are facts that belong to the patient, and it is patient information. But together with that, we're often assessing the patient, engaging with the patient, planning with the patient on what our next steps are. Now I'm applying my clinical mind, my interpretation, my diagnostic skills to that. And those are my notes that I'm making based on what the facts and the information is that the patient has given me. If we were able to, and we typically don't, I think in our practices, we merge those into one set of documents, put that in a file, and we say, okay, there we go, there's my SOAP notes, and we move on forwards. But portions of that belong to the patient. It's their information, and parts of that is what I've interpreted out of my engagements with the patients. So if we really had to cleave it down the middle, we could say there are two sets of notes, the patient notes and my clinical interpretive notes, and they are separate. And if you have them separate, it kind of makes the debate a lot easier. But I think what is important is that prior to disclosing that information across, we need to be sure that the patients have given permission to do that. It is their personal information.
Yep.
Know that the elements of the POPI Act are being promulgated, or further chapters are being brought into effect from the 30th of June. So that's soon. And we need to be very sensitive to these elements, which Neil knows a lot more about as far as what that regulatory framework looks like. But do pause. And if you pause long enough and the scheme really wants that information, they can subpoena you for it. And of course, at that point, legally, you need to then provide that information across. But I think that's just more from a clinician's point of view about how at least pause and not just say, absolutely, here's photocopies of it, where shall I send those? You need to pause and engage and understand the purposes of those. Neil?
Yeah, so I'm also, we discussed about this topic before we logged on for this. And I think I'm on the same page with you when it comes to the ownership of the notes being the practitioner's notes. The information is the patient's information in the sense that it's their story. They're never going to lose their story. They're never going to lose their history. It's there. It's part of them. What you've done is you've captured those notes on whatever means, whether it's digital, whether it's handwritten, whether it's a photo, whatever it might be. You've captured that information. That is your note-taking. That belongs to you. The information is theirs. How they gain access to that information, it depends on the situation. So obviously you don't want to be hostile, and you don't want to say to the patient, well, I'm not giving you this information. You want to be forthcoming. You want to share their information because you're engaging with them and it's in the best interest of the patient to give that information. provided that you've got the right kind of note taking. So if you're taking inappropriate notes, it's not very constitutional. So if you are taking information about sexual preference, why are you taking that? If you're taking something about HIV status, is it really appropriate for your practice and your clinical engagement with the patient, or are you just taking it for the sake of taking it? So it forces you to be very appropriate with your note taking. Yeah?
We often ask the patients what is their marital status. Now, I beg the question, what has that got to do? Is it going to change the way that you're treating me? Is that really important information?
So there is ethics in terms of privacy, which is constitutional, the right to privacy. But then it goes one further if you have to look at the National Health Act in terms of confidentiality. That's a practitioner duty that they owe to their patients, and it's binding. You have a duty. So if the patient comes to you and asks for their notes, obviously they have a legitimate reason for that. If a third party comes to you for the notes, they don't really have access to those notes unless there is a legal requirement. So if they've been through the legal process and they've got a public access to information request or whatever it may be, then they may have legal grounds to gain the information. Otherwise, they don't. And you shouldn't be kind of willfully handing over the information just because. So again, you need to pause, reflect, and say, is this a legitimate request? And it goes beyond I was taught this way, and we were taught this way to kind of just hand over the notes. Reflect and say, where is it written in legislation? So if you go to the National Health Act and you look at Chapter 2, Section 14 on confidentiality, are you allowed to disclose these notes? If you go to the Children's Act, what notes can you provide on an adolescent? If you go to the Mental Health Act, what can you provide for somebody who's got a mental health issue? So those are things that you need to know as a practitioner.
Sure. But I mean, there's so many pieces of legislation. Where do I go? I mean, surely if I find one piece of information in the HPCSA booklet, then I use that, right? Or is there a hierarchy of how I approach that and which one trumps which one?
There is a hierarchy. So you have superior legislation and then you have subordinate legislation. So what is the top of the tops? It's going to be our constitution. So the Chapter 2 Bill of Rights, you'd see that practitioners have their rights. And SAMA has done a very good article on this where they unpack the practitioner rights and the patient rights. So you have rights as a practitioner. So when you look at the superior legislation, that would be the Constitution. Then underneath it, you'd have the National Health Act. Underneath it, then you'd have the Mental Health Act, Children's Act, etc. Lower down the order would be the Health Professions Act and the Medical Schemes Act. And beneath that would be the guidelines. So the guidelines are not legislation in themselves. They're just guidelines. They talk to the National Health Act and they talk to the Health Professions Act, but they're not law.
They're not gazetted as such, are they?
No.
It's an interesting question.
It's important to know that you have rights as a practitioner. So if the medical aid approaches you and they say that like the notes, you don't have to supply the notes. All right. So pause, reflect, speak to the patient and say to the patient, your medical aid has approached me for your notes. How do you feel about it? They could say, yes, you can share. And in which case you don't actually have to give the notes. You can give a report or a summary on the notes until you subpoena.
What if they refuse?
So there's the thing, is if the patient refuses, that's an interesting scenario because then they'd have to go back to the original contract. So I'm with a particular medical aid. I went back and looked at the contract. When I signed my contract was back in 2007 odd. So not the original contract, I got an updated version. And there in writing, in black and white, clause 13, it says that they have access to my information. However, you'd have to then update that informed consent on a regular basis with the scheme for them to be allowed to go and access your information. So every year, like we should every year update our informed consent, they should too. So if they want to have access to the patient's information, they have to say to the patient, all right, we'd like you to consent to sharing your information this year because a lot can change. Your HIV status could change, a lot that you might not want to share, your mental health status. And then all of a sudden they say, but in 2007, you signed this clause 13, and now we need to enact it. And constitutionally, it's a written agreement. It is enforceable, but you have to realize that it would probably be challenged in the Supreme Court and then probably go constitutional if the client refused.
But there's two parts to that. Is also that in the POPI Act, it states that sharing of information must be for a specific purpose and defined. So a global blanket statement saying all your information will be shared with whoever is required, from whoever is required, because we're your medical scheme or we're contracted with you as such, wouldn't necessarily stand muster in the eyes of the POPI Act. And again, as you rightly say, 2007, that wasn't in place, and now it is. So law changes, and we have to reflect on that. There was a question that's just popped up now, though, is, so what happens if you do share that information without the patient's permission? What would the law do to you now?
So it depends. It would depend on who challenges you. So there has to be a reason. Yeah. So if the patient lodged a complaint, or a fellow practitioner lodged a complaint, or the scheme lodged a complaint, but if you're sharing the notes without consent, it is a legal infringement, but somebody would have to catch you with your pants down to know that. So you'd have to, there'd have to be a grounds or reasonable suspicion to know that you've shared the notes without consent.
Yeah.
So Neil, here's an interesting one for you. What happens when you are seeing a couple, one of the couple dies, and you are asked to engage in an interview with another health professional for the inquest? How do you get permission from a dead person? Or is permission from one half of the couple enough? It's a tricky one.
You have to go to, no, there is legislation on it. It's the, off the top of my head, I can't recall the exact terms, but if the deceased and death and dying, there is an act that covers it. And they'll step by step say, in this event, the next of kin will have the following rights. But you'd have to see why you're sharing the information, and it would have to be for a reasonable kind of request. It can't just be like, we just want to have access to this information. It has to be, we need this information for the following reason.
Yeah. Okay. Lani, I think what's important in those kind of cases is that, again, pause before engaging. It is so important that each situation's got its own nuances. You're not going to get a blanket answer that's going to cover all of these. And I think it's so important that, whether it is a fellow colleague asking for information, whether it's a medical scheme that is running a forensic review or audit, or whether it's the Department of Health or the HPCSA asking you these questions, you have to pause and review the situation, get the appropriate counsel, make sure that you get legal counsel if you feel that you're going to be putting yourself at risk. So get that from the right people. Consult with your association and society to get guidance as well. They will point you in the right direction and assist. And then I think also another very important thing, just to continue to drive home, I think the vast majority of those on the call now have got claims made cover. It's a specific type of cover rather than incident-based cover, but claims made cover. Please, guys, keep in mind that if at any point you get an inkling that there might be a claim against you for billing, for marketing and advertising, for patient treatment, whatever it might be, if there's an indication that you might have a claim against you, in other words, a patient throws their toys out, slams the door behind them and says, you're going to hear from me, you need to notify your underwriters. You need to notify them that there may be a potential claim against you. Because if in the future there is one and they can show that you didn't notify them at the time that there was an indication there might be a claim against you, and an email that was sent or some shouting that happened in the heat of the moment, that claim might be repudiated. So it's very important that you do those three things. Consult your association, society, get legal advice where required, and also make sure you report that.
Okay. Deon, talking about claims, and I'm going to move away from the topic a little bit. Is it deemed ethical to charge a different rate for a medical scheme patient versus a private patient?
Okay. Yeah, what a fantastic question, and it's so loaded. And Neil, if you can back me with the various parts of legislation again. But what we need to also be sensitive to is price fixing. So on the other extreme is that everyone must charge a specific rate, and if you don't, you're kind of breaking ranks. I mean, that's collusion, that's price fixing, and the Competitions Commissioner would frown upon that. Okay, so that's the one extreme. The other one is it's a free market. You need to be billing what you need to be billing. It's a willing buyer, willing seller, not a willing buyer, willing seller, but a willing buyer. And it's a contractual relationship. And I think that's important, is that very often the contractual relationship relating to how you're billing the patient is not always in place. We might be very good with our informed clinical consent to say, I'm about to do the following procedures. This is the risk. This is the benefits. You need to understand the following elements of it. You've got a chance to ask questions to a clinician, and I'm satisfied that all my questions have been answered. We do that clinically, but do we do that from a billing point of view? And I really do encourage practices to have an informed clinical consent document separated from your informed financial consent, where you say, my billing policy for the practice is the following. This is what we're going to be charging. This is what your medical aid may or may not cover. If they don't, you're liable for the difference or the whole lot, and you claim back from your scheme. Paint that up front so that the clients know what they're contracting into and they know what they're in for, and they don't get a surprise later on. Communicate to the patients. So I think that's the most important part. But then the question is, so I might have varying rates. Is that fair? Now, it does come down to that. Is it fair? The Consumer Protection Act will look at the fairness of the process in you providing services or products to the public. And in this case, there was a question, and it's a great one, is can I charge a different rate for people paying cash? People often use the word private patients versus medical aid patients. Now, I'll take this from a business point of view. From my business, it costs me the following, and I've done the calculations from my rent, from my salaries, from my anticipated return on investment, my profit margins, all of those that I've calculated into my practice. I'm seeing 10 patients a day, which is what I planned for. My profits are looking like this, and I can pay my salary that I'm hoping for of that. But to achieve all of this, I need to be billing 342 Rand per patient, right, for a session. Now, I'm not saying fix that and charge every patient that, please. That's my average fee that I look at. But that then I can determine and say, well, typically I'm charging these codes. What's my Rand conversion factor? Or what is my schedule of what I'm charging for my treatments, right? Again, not cookie template that and bill everyone the same, because your treatments are different for each patient. Right. But that will give me an idea of what it's going to cost me to run my practice, and that's what I charge. Now I look at the schedule of medical schemes and I see, but they pay more or less or the same. That's neither here nor there. That's the patient's benefit design that they're paying for. It's an insurance. So that's how I get to my price. Now, if my price comes to 350 Rand for medical aids, including my EDI costs, my collection costs, I've got to get somebody who's appointed to follow up on these claims, get pre-authorization numbers, all those extra costs running my practice, it's 350. And a patient comes in and says, I'll pay you cash. I will do all of that work. I'll claim it back from my medical aid. In other words, they're reducing my overhead costs of EDI transactions and all of the rest that I require within my practice. I could make a choice to say, I'm going to give you a 10% discount if you pay me cash, because cash is king. I'm getting it right now. If I do it with the medical aid, I might get it in 30 or 60 days time. And it's going to cost me a whole lot more to do that. So to me, there's a lot of rationale around that. It is a fair process. And another medical aid patient overhearing the conversation will go, hang on, why are you charging him 300 when you're charging me 350? And you can say, well, he paid cash. You're welcome to also get that discount, but then you also need to pay cash and claim that back from your medical aid. So as long as there's a justifiable, fair discrimination, the Consumer Protection Act says that you can discriminate, provided it is fair discrimination and not unfair discrimination. So be sure you can justify that.
Yeah, and maybe just to tag onto that question, and thanks for the answer there, Deon, is it then fair or ethical to have two different rates if you've got two different practices in different areas? Let's say the one practice is in a very affluent area versus another area.
I'll just say something about beneficence. So your decision making needs to be made in the best interest of the patient, not in your best interest. Mm-hmm. So if you're making decisions because the person rocked up in their Porsche and you kind of see their car keys on the table and you're kind of like, yay, yes, this person's got cash. I'm gonna charge them. That's not ethical. But if you wanted to, say, if you're going to go work in the community and there's a need for the service that you're offering, but you know that they can't afford it, there's no problem in charging them a lower rate, because it's out of the goodness of your heart that you want to charge them less. If you work in an affluent area and you know that your competitors in that area are charging a certain rate, you need to earn a living. You have to be able to bill, but it shouldn't be from a devious kind of drive or desire to kind of cheat people out of money. It should be of a beneficence, and like, I want to do good in the community, so I want to charge them less because I want to help them and I want them to get better, but they can't afford me, so I'm going to drop my rate there. So it should be seen as a dropping of rate rather than I'm going to escalate my rate on the other side. So it comes down to how you phrase it and how you what your intent is.
Uh-huh. So would you say the same applies, Neil, then to pensioners, for example? I like that word, the beneficence, you said.
It's one of the 4 principles of Beecham and Childress. So autonomy, justice, beneficence, and non-malfeasance. Mm-hmm. Beneficence. I can never get the word right. However you do it.
So let's throw co-payments or split billing into the mix here.
Okay, fantastic. So this comes from, and I trust everybody does attend, I guess it's going to be virtual now, that they do attend the HPCSA roadshows that are registered, those that are registered with the HPCSA. They really are valuable interactions and very clear directives, and the direction is just amazing from the podium. The typical speaker that's on those is Dr. Quinda. I think Lani's got some fantastic news for us later, but I'm not going to share that right now.
Steal my thunder.
I won't. I'll just pause there. But the directors are really cool, and Dr. Quinda, who's the ombudsman and the current acting CEO registrar, has made it very clear around the co-payment elements. And one of the questions that I always ask is, who's allowed to charge a co-payment, or who's allowed to charge we sometimes call it a levy, a co-payment, or a administration fee. Who's allowed to charge that? Now, the straight answer is not the practitioner. All right, you're not allowed to say my fees are $350. However, if you're with that medical aid, I'm going to hike it by this administration fee. And you can't be tagging on over and above. If that's what it costs you to administer, build that into your calculation so that instead of $350, it's $360 that you're charging for your services, which covers the fact that you now suddenly decided to electronically submit your claims or whatever it might be. So that's a general thing. To tag a cost on as a once-off or as an ongoing fee is not something that you can do over and above your rates that you're charging. Okay. However, if your fees are 400 Rand and the medical aid only reimburses 350, you can see there that there is a 50 Rand copay or a difference that the patient has to pay. But it's not because you added on $50. It's because your rate's 400. The medical aid only pays 350. So they've decided or impacted what that copay is. Another medical aid pays the full 400. You're not going to be charging another 50 on top of that because your rate's 400. So the medical aid is determined there's no copay because they're paying the full benefit to the 400 Rand. So if there's ever a difference, it's not because you've tagged it on. So now you have the same two patients coming in. The one, the medical aid pays 350. The other one comes with a richer medical scheme and they pay 400. And now you tag 50 onto both. That doesn't make sense. So you need to determine your rate. And if there's a shortfall by a scheme or payer or whoever it is, the employer, whoever it might be, that will then impact on what that copay is. But hiking a copay onto every treatment, depending on where it fluctuates, and you just adding on an amount over that, I can't understand how that is calculated and is a fair process.
Perfect, thank you. Neil, perhaps a question for you. Deon, you touched on different medical schemes charging different rates. One of the questions that came up last week was, is this deemed ethical? Can medical scheme A charge X amount for a specific procedure code? Medical scheme B charges Z for exactly the same procedure code.
Neil, yours.
Under the bus. So, if you have to look at it, we've just dealt with this, like we're discussing now that practitioners are allowed to do it, but then the medical schemes can't. So it's kind of, well, if you're allowed to do it, why can't they? And the reality is that it would be anti-competitive to start dictating to them what they need to charge. So they've got their back end, they've got their stats and their data on how they protect their fund. And different schemes will have different claims. So you might have one scheme that has really like a lot of people with NCDs, and their claims on that might be a lot higher. So they've got to adjust risk at all times so that every year they'll assess. Same as with our malpractice insurance. You'll have claims made against bios or physios or OTs, and that'll adjust the premium that you have to pay every year. So every time you have a claim, it has an influence on the back end. So what they'll say is we need to balance the fund. How much do we pay? So some funds might have, well, very few claims from biokineticists. Well, they'll say, okay, let's just, maybe we can pay a little bit more. Some will say, well, we're getting too many claims coming in from psychology, so maybe we need to cut back on the spending on that. So they balance according to actuarial science behind the scenes. I'm not an actuary, so I can't give you the ins and outs in terms of how they do it, but they are entitled to charge and charge premiums that they deem fair, and they also are entitled to choose what they pay out. It's part of the Council of Medical Schemes. They're allowed to do that.
So I think that's the important part is people are saying, is it ethical that medical aids do that? Now, my question is against which ethical regulations? And typically when we're saying that as clinicians, we're saying ethics, and in other words, as per the HPCSA regulation. What is the relationship between the HPCSA and medical schemes?
They can talk to each other, but it's the Council of Medical Schemes dictates to medical schemes. The Health Professions Council could issue a letter to certain medical aids, and they have done in the past, where they'll stand and defend medical professionals, and that's their role, because they've got two roles: is to protect the public and guide the professionals. So if in the guiding the professionals is also protecting them. So when it comes to ethics, ethics it's also misinterpreted. We think that the rules and the law is ethics. It's not. If you speak to a bioethicist, it's completely different. The guidelines are what we refer to as ethics, but those are guidelines. They're not ethics. Ethics is something it's the way you act in your those 4 biomedical principles. That's ethics or bioethics. So when it comes to ethics of medical schemes, it's not really ethics, it's law. What does the law state? What are the obligations for the Council of Medical Schemes? And the laws would be around the Competition Commission and the Consumer Protection Act. So have the schemes notified the patients, yes or no? Have the schemes entered into a contract with the patients, yes or no? And then they're allowed to, within reason, enact the contract. So it is a contract agreement between parties. Medical scheme is entering into a contract with the patient and then funding according to that contract.
Sure.
Okay. Deon, anything to add to that? Or can I move on to maybe one of the next questions?
Yeah, we've also got questions popping up on the side here. I don't know if we can maybe come back to some of those a little bit later, because there are some very interesting ones.
Pick one. I wanted to go there. Is there an interesting one that you wanted to answer at the moment, Neil?
Francis addressed something with notes, so sorry we go back to it, but what happens to notes when the practice is sold? Well, there has to be written consent from the patients and all of the patients that are then handed over. So you can't just go and say, I'm selling my patient book here, take my notes. It doesn't work that way. Deon, you've lectured on this. I mean, you know the intricacies and you've had this query many times.
That's a very sticky one, because practices are often trying to bolster the value of their practice when they're selling, to say, and they often add things like, firstly, goodwill. And this is a whole conversation in itself, is how do you build value in your practice? How do you build your asset? And I think when you're reaching for goodwill as in the first draw, I think you've let yourself down. I think there are ways to build value in a practice without leaning heavily on goodwill. But we often are saying goodwill. We're often saying, I'm going to sell you my patient records. I really want to pause there. And the other one is, I'm going to sell you my networks. You know, my doctors refer to me and I've contracted them, and the doctors will refer to you when you buy my practice. Now, it's the doctors can refer to you, but it's a patient's choice where they go. It's not a forced hand. So be careful of that one. And the other one is, you know, handing over the keys to the practice and say, by the way, that little key on there is all my patient notes. Remember, that's what you paid an extra 200,000 Rand for. They're your patients, go. You're going to have to contract with those patients. You're going to need to be sure that they've given permission for that information to be handed over from practitioner A to practitioner B. And also be sure that you've got access to those notes. You can't just hand them over and say, I'm out of here, because 3 years later, you're going to get a call from the HPCSA or some party to say, you've been called relating to a specific patient interaction you had, or even some other practitioner. This often happens in the medical legal space. It's not even a claim against me, but the fact that the doctor also saw the patient in that rehab process means I'm part of that case. Now suddenly I must remember who the patient was. I can't even picture what they looked like, and my notes have now been sold and I don't have access to those, or I'm living in another country. So please be careful of that. It's not just added in as an asset value and now I'm going to cash in because I'm selling patient records. We're not in the business of selling patient records. That's their personal information in there.
Yeah. Deon, you were mentioning things that happened historically, and there's an interesting question that came up last week was, if a patient paid me and claimed back from the scheme, the medical scheme, but now a few years later, there's a clawback, does the scheme claim back the money from me, the provider, or does the patient need to pay me back? How does it work? I mean, there's quite a few parties involved there.
That's a very, very sticky one. Because essentially the scheme is trying to claim back their financial exposure that they underwent as a result of where they feel they paid inappropriately in retrospect. They're looking back on it and going, we actually shouldn't have paid that, and they need to then claim that back. So who did they pay that to, and who should they be claiming that back from? It's a tough one. Because they often want to protect the member, because that's their client paying the premiums. You must remember that the healthcare practitioner is not their customer. We often feel like that they're accountable to us. They're not. Unless you've signed a network agreement with them, you're accountable to them then as well. So I think be careful of that. Yeah, Neil?
So yeah, the first thing when it comes to a clawback is contact your professional body to get input as to, has anyone else experienced the same? And then when it comes to that 3-year window, that's a standard prescription. So in terms of the legal term prescription, you have 3 years in which to lodge a legal case. So they are entitled to go back 3 years, but you also are entitled to challenge that. So there has to be reasonable suspicion as to why you've acted unethically, and then you'd have to have contact with your broker, obviously, to notify them there's a claim, and then get legal representation, because you need to make sure there is a just reason for wanting that money back.
James, can I change the topic of the conversation a little bit, and we move back to telehealth slightly? telehealth, and this is a question that was asked last week as well, and it's the first time that it comes up. Deon, I think hopefully you can answer this. Am I allowed to use telehealth in the COIDA space for patients, and how do I bill in that area?
Yeah, very, very interesting one. We've, over the last week, just tried to get our hands on some legislative information around that to give us that framework to work off. Neil gave me a stern talking to earlier to say, opinions and all of those things are all great, but if it's not in black and white, you must be careful on how you apply your mind. So we were looking for the black and white of that. We haven't seen formal communication from COIDA, but I think their approach going into COVID, as many have been, is that they will cover for essential services in that time. So if you had the validation, you remember you're an independent clinician who's doing what's best in the interest of the patient, and you're looking at that and saying, I need to use certain avenues or approaches, whether it's jumping in my car and doing a home visit or a work visit or a telehealth platform, whatever it might be, and this is essential for the patient's well-being and care, then you need to be considering that as part of your clinical care of the patient. Where we pause, I think, and this is so important, is that when we pause to say, I need a funder to give me permission about what I can do clinically, we've lost the plot, guys. Then we may as well all just go and get employed by medical schemes, because it's not a funding decision. It has to primarily be a clinical decision. And should that then be paid? That's the second conversation around that. And if not paid, then who is going to pay that bill, or are you going to do it for mahala? Those are your choices.
So if you as a healthcare provider needs to apply for a specific benefit regarding a specific condition on behalf of your patient, and the scheme comes back and they say, oh, you will, let's say you applied for 12 sessions, but the scheme only authorized 6.
Let me. Okay, so we're moving now from COID to the schemes, and I think it's important. We're talking about funders in general. So whether it's RAF, whether it's COID, we have to position ourselves as independent clinicians about how we approach in the best interest of the patient. And this is a pet peeve, and I'm so pleased to see some of the names on the list of who's attending. Ray's there, Megan's there. It's practitioners morally from my previous practice. So welcome to Retan and Partners. Shout out to you guys. It's nice to have you guys here. But in that space, we often were presented with a dilemma. It was a multidisciplinary group practice, physio, OT, and speech. And we would say to a paraplegic patient, for example, from our clinical assessment, we feel you need 12 weeks of inpatient rehabilitation. All right. This was a while ago, but and that's based on our evidence, our understanding, our experience in rehabilitating patients. We need 12 weeks. We put that motivation through to medical schemes, and the scheme comes back and says, we authorize 4 weeks. Now, they're not authorizing 4 weeks from a clinical point of view. They're saying we got the funds to cover for 4 weeks. Now, the error we can make as clinicians, and please, we have to guard against this, is we just said to the patient, I think you need 12 weeks, in my professional opinion, based on evidence and best practice. You need 12 weeks. I'm going to communicate that to your medical aid. If the next conversation is as follows, I'm sorry, but your medical aid is only paying for 4 weeks. We're going to do 4 weeks of rehabilitation. Let's quickly see how we're going to do this. What you've now done is allow the funder to make a decision on what your clinical approach is. Our approach should be, I still think you need 12 weeks. Your schema said they'll pay for 4 weeks. Where are you going to get the money for the other 8 weeks? Let's make a plan. But clinically, you still need 12 weeks. Nothing's changed. Otherwise, I was taking a chance before, right? And if we can't make a plan, then listen, we're going to do 4 weeks. I know a good public state sector hospital that I can refer you to. I will engage with that physiotherapist. I'll give them a handover report, and you can continue your treatment there. But I still advise that you need 12 weeks of rehabilitation. So that's just a simple example, but we very often are jumping through the hoops of the funder and shaping our clinical treatments in accordance, and that's dangerous. Whether it's COID, RAF, a lawyer group, whoever it is, you have to do what's clinically appropriate for the patient first and foremost.
Yeah, I think it's back to something that Hester Heisarman said last week, where the medical schemes or the administrators needs to keep on focusing on the risk management. Healthcare providers needs to focus on the clinical management of the patient at the end of the day.
Yeah. And the risk management we're talking about is the risk to their central funds that are there to take care of the entire pool of patients who've put their money together and said, we're asking you to take care of this and spend it wisely. That's the risk that they're trying to cover on that one from a funding point of view.
All right. Guys, let's quickly talk about locums, because there's a few questions that came in regarding locums. One from last week, if I can only find it now. If I have a locum and if you have a locum and sorry, let me just quickly try and understand this. What's considered an appropriate amount to bill for telehealth from a locum? All right, so it's the telehealth and the locum bit.
Mm-hmm. So I think the first part is the assumptions we make and the words we use. I think it's very important. We have to always consider the words we use. And when we use the word locum, firstly, I think many people are using it incorrectly. And I think even in this question, what they're meaning here is somebody I pay commission salary to, a percentage to. I remember that question. And we're often using that in the word locum, but that's not what a locum tenens really is. It's somebody who steps in for you and works to a maximum, the HPCSA is saying to a maximum of 6 months. In other words, somebody temporary who steps in to support and assist your practice. If you go on maternity leave, take sabbatical, go overseas, decide you need some time out. That is essentially what we mean by the word locum, but we've translated that into an employment payment arrangement rather than the status that it is. You can have a permanently employed person who is paid on a per patient basis, a per day basis, a per month basis, a percentage basis, and there's a long conversation around the percentage commission-based incentives that are in place, and we have to be careful of perverse incentives. We can probably spend a whole webinar on just that. But when we're talking about a payment arrangement or how I pay somebody, it could be a permanently employed person, temporary employed person who's paid percentage. And I think that's what this question means is when I'm paying a percentage over across to, and I reserve again, that needs a long conversation, but in the interest of answering that question, I'm going to say, if you do choose to pay a percentage, they're asking what is an appropriate amount? Is 50% an appropriate amount? And I'm going to go back again to saying, if you have to understand what the overhead costs of running your practice is. You need to understand that in order to cover pay rents and all of those things, you need 40% or 60%. I've seen so many practices, we've done full reviews. And when you start balancing the commissions or the percentages that they're paying across and add everything together, the costs of running the practice are 110% of the revenue that's coming in, and they're running at a loss and they're wondering why. Because you're reverse engineering it. You're saying, I am so desperate to get a locum in, I'm willing to pay 60%. But the other 40% is not enough to run the practice, and you're wondering why it's not working because we've reverse engineered it. We should be saying the most I can afford is 32% to pay towards salaries, whether you're locum or permanent or whatever. That is what I can afford to pay across for salaries. And that varies from practice to practice, where you are, what your overhead costs are.
Yeah. Neil, a quick one for you. And this is an age-old question. How long do you have to keep your notes for, and has that regulation changed?
So it hasn't changed, but it depends on the patient really. So if it's a mental health patient, it's for life. You have to keep it for the life of that patient. So you can't go and say, well, every single note in my kind of filing cabinet has the same kind of time frame. It doesn't. Children, same thing. You can't keep the child's notes for more than a set period of time. So you need to go look at the Children's Act. You need to go look at the Health Professions Act. And you need to look at the Mental Health Act. If you don't work with people with mental health issues, then don't reflect on that. If you don't work with children, don't reflect on that. But then look at the standard 6 years of retaining notes. Mm-hmm. And then also you got to keep in mind with the destroying of notes, you can't just go and keep notes indefinitely. There are guidelines in terms of destruction of notes afterwards.
Sure.
So
I think the beauty there is that the further question is, as you rightly say, the Consumer Protection Act says you can't unnecessarily keep information for unnecessarily too long. So our default has always been, I'll keep all the patient notes for always until I sell the practice or until I die. That is also infringing on CPA clauses to say you can't unnecessarily keep that for too long. So 100%, but the HPCSA for one has got really good guidelines on retention of patient notes. There's a booklet on that one. So you're right. And there's also the issues around occupational health. So if you suspect the patient has got something like asbestosis, and it is an adult patient who is of full mental capacity, that doesn't mean that 6 years applies there now automatically, because if you suspect it is a work-based, you might have class action 20, 30 years from then, silicosis, asbestosis, and all of those, you should then sort of apply your mind and say, but I think I should maybe keep these notes for longer than this.
And looking at the current scenario with COVID-19, we don't know what the long-term effects are. So it could actually be that if anyone has tested positive for COVID-19, you might be required to keep their notes for a lot longer. So we don't actually know. So
we don't know yet.
At the moment, look at the current guidelines, but also be very careful of getting stuck in the way I was trained at university. And I think that we've had a couple of queries this week with the way I was trained. So always just go back to the guidelines and have a look and read and see, okay, what is the latest on this particular information? So the question from Francis was quite applicable, but you can't rely on this recording. You have to keep updating yourself because it might change tomorrow. We don't know.
Same as what you do for your clinical practice.
Yeah.
If I had to go back on 15 years ago to look at what I learned in varsity, it's changed.
I hope so. Yeah, I
Another
think
question.
a good. Sorry, Neil.
Sorry, do you want to go?
I think a good clinical practice is or discipline is to separate your clinical notes from, if you are seeing pediatric patients, those under 18, is to file those separate. If you are seeing patients that aren't of mental capacity to manage their own affairs, to file those separately, and then your if I can call it, your general patients separately as well. That'll give you at least a handle, more than what we currently have, on how you're managing those notes and when you get rid of what. I think it's also important on how those notes are stored, and obviously the physical storage of documents and notes versus scanning and electronic storage thereof, ensuring that if you are doing that, that is secure and password protected. In which territories is it saved? Under which legal jurisdictions? There's a lot of conversation around that too.
It's okay to save your patient notes. Let's say if you immigrate, if you move somewhere different to South Africa, to just save those notes electronically and destroy the paper in an appropriate fashion. Is that okay?
It is crucial that you obviously have eligible notes that you can reference back on, that are indexed and that you can find them. Because there's one thing going through filing cabinet and going A, B, C, D. And when you start electronically filing that, how on earth are you going to find those? So make sure that you are able to do what you need to do with clinical notes. Are they password protected? And again, people often think, well, I'm just going to put it in a cloud storage service, and there's multiple, Dropbox, Google, whatever it might be, OneDrive. But where is that really being stored? It's not in the cloud somewhere. It's in a hardware services physically somewhere in some territory. And if that is being stored in Ireland, they've got different regulation in that space versus in South Africa. And you're starting to add a tremendous amount of complexity to the legal framework in which you're operating. Neil?
I just wanted to touch on Anita Shaw's question about somebody calling to ask for your rate. It's very common. People are price shopping, so they're determining their practitioner based on how much they charge, not on how good they are. Yeah. It's incredibly frustrating. It's kind of like, I'm good, come and see me. But they do. They phone you, they want to know how much you charge. I urge you not to make it into a spice bazaar. You're not there to haggle over price. So don't try and kind of barter with a person, because then you're kind of eroding your self-worth. So what I would say is that you have a rate for a reason. So if you work in a particular area, that's your rate that you charge. And if the person doesn't want to come see you or can't afford to come see you, it is unfortunate. They could go down the road and see somebody else. Yeah. And you have to keep that in mind, that you can't please everyone all of the time.
I like to say that, when these conversations, the quicker you can move from a price conversation to a value conversation, the better. If I can go and see a physiotherapist, I'm going to see one tomorrow for my back. If I can go there and they're charging me twice at 1,000 Rand a session, and I consent to that, and it's an appropriate bill for the expertise and so on, but after 2 sessions I'm sorted, versus somebody who's charging 100 Rand but they never fix me and I end up going back time and time again, I'm very quickly after the fact going to do a value calculation. Before, I might do a price calculation as a consumer. But we need to be having the conversation with the patients and educating them as far as our position on value-based conversations. And I think that speaks again to I have a serious bugbear around the fee-for-service structure we currently operate in versus a fee-for-outcome or fee-for-value. And I see we're slowly starting to adopt that thinking on how we as clinicians put skin in the game to say, it's not just about me spending so many sessions, and if you're better, that's great. If you're not, at least you've paid me. We should be having a conversation to say, I'm going to put my name on the line here, and I'm going to do an intervention to get you better. And when you're better, I want to be remunerated for that. So that's a whole different conversation, and we should be taking charge of this before the schemes do it for us.
No. Guys, before we run out of time, let's quickly talk about billing or procedure code rules and guidelines. So obviously there's RPL, we know it's outdated, it's been with us for a while, but the medical schemes still use it, versus some of the societies or association took the initiative to start updating those. Mm-hmm. Which one should a healthcare practitioner follow?
Neil? You want this one?
So it's a one. As an autonomous medical professional, you should not have somebody else dictating to you as to which ICD-10 code you should use. You should use your clinical judgment. Where do you find that information? On the master industry table. So you can go on to, I know that we've shared with our organization that you can download the Excel spreadsheet. You filter column J to only include clauses or only include conditions that are claimable. And then you've got to look at saying, what is the person presenting with? If they're presented with a certain condition, you then need to tell a story with your claim. So you've got the condition, you've got maybe there's a whole line of ICD-10 codes. You might have three ICD-10 codes on that line, and then you have the different RPL codes that go with it. So when you have the funder on the back end, they should see a story. They won't see the patient. They don't necessarily have the patient notes there, but they see a story that's being told. So a lot of practitioners get scared of this. They don't like coding because it's scientific, mathematical. It puts them off. But if your codes tell a story and they reflect what you've done in your notes, you should be safe. Where you get that information from, it's challenging. I mean, there are ICD-10 coding courses that you can go on. Again, they're not going to tell you a template as to how you need to code. They're not going to tell you this is the particular code that you use for Parkinson's, because if you're a GP treating Parkinson's, it's going to be different to a person who's a biokineticist who's not treating Parkinson's. They're treating
symptoms,
the conditions associated with Parkinson's. So you have to look at it as who you are and what you're doing with the person, not a kind of a document that you go to and it's all there, because as a biokineticist, this code applies to me in this context. It's the story that you tell with the coding.
Lonnie, I think your question was also around the procedural coding, not just the ICD-10 code.
Yes, procedure.
And I think this challenge again is, I will ask you again, what have you contracted with the patient? I think that's the most important. You know, a patient will choose whichever medical scheme they choose, where they find value. And they should be voting with their feet. Some medical schemes do adopt new codes that come in. I think your example before was in physiotherapy space on shockwave therapy, and I think the chiropractors have also brought that into their coding. And some schemes will look at that and say, we're happy with the evidence and we will pay for it. We've decided that we're going to take the risk in paying for that because we feel we're going to get good service and good outcomes for our patient group that we're taking care of. But if you're contracting with that patient and you're saying, listen, I'm going to be using codes here that are developed by my association, my society. Some schemes have adopted it and some haven't. Where they haven't, you're going to be liable for that. But I'm going to be billing you that because that's what I'm going to be doing, because it's best practice guidelines. And it's in my clinical opinion, it is the best approach to manage your healthcare and to get you better. That's where the conversation needs to be. Where we shape what we do and how we bill according to whether the scheme will pay it or not is a very dangerous place to go, guys. Really, I have to caution against that.
Yeah. Talking about billing, we've been talking about individual patients most of the time, and there is a question that came in with regards to clinical note keeping, with regards to group practices. Maybe Neil, you can let's finish with that question and then we can start wrapping up because we have run out of time yet again.
So when you look at a group class, you have to look at it as not just the group, it's individuals in a group, and you're rendering a service that it makes it more affordable for them to attend a group session than a one-on-one. You still have to keep patient notes for the individual. You can't just say, I'm going to write group notes and then hope for the best, because say it's a cardiac rehab class. So the person's coming in for a cardiac rehab class. They're not all going to have the same blood pressure. They're not all going to have the same response, RPE, heart rate. It's going to differ from person to person. So if you happen to get challenged on an individual who came to a group class and something went wrong with that individual and you only had group notes, how are you going to defend yourself in court? How are you going to defend yourself against a claim of negligence or liability? So you need to make sure that you document your sessions carefully and thoroughly. So don't just blanket prescribe like everyone did this exercise, and the next exercise, or this is what we discussed in our group psychology session. You need to be very specific about the individual because they are important.
Because obviously the individual reacted differently to whether it's a psychology session or an exercise prescription, et cetera, and you need to note that. Brilliant.
A quick apology. Sorry, so John Edward said, what is a mental illness? Apology, I'm not a psychologist, so if I use that mental illness incorrectly, it's a mental health disorder that's conceptualized in the Mental Health Act. So apologies, I'm not a psychologist. If I spoke out of turn, I'm a biokineticist.
Thank you, Neil. Thanks for that. Guys, we do need to start wrapping up. Let's maybe start with some closing thoughts. Deon, maybe over to you. We've really jumped from one question to another, but I think we try to cover as many topics as possible. And just a reminder that there will be a question and answer document available within the next couple of days, and we will post that on the EZMed.solutions website. Deon.
Thanks, Lani. Yeah, thank you. We have jumped around, and what we attempted to do last week wasn't planned to be a part one of a series on ethical billing in practice. But because there were so many questions and answers, to answer those comprehensively would really just we felt that a conversation would be better, and I trust that we've answered those, and that we've moved and flexed to those. We continue to position our webinars in such a position that we flexed and guided by the audience. We seem to be having a stable 500 people on our webinars, and we're seeing similar names there, and we really do appreciate your support and for joining us every Thursday at 4. And you guys will guide us on these, and that's what we did. So yesterday, straight after this, we'll decide again, what is the next things we need to be looking at based on the content and the questions that have come through. So that's why we birthed it into a part 2, to really answer those questions. So we trust that we've done that, and that we jumped around and been guided by you guys on your questions. That's why we've also been watching the Q&A in the chat. So thank you very much for giving us the direction there and pointing us to where the challenges really are. And we intend to continue that, and we intend to continue every Thursday at 4 o'clock.
Neil, maybe some closing thoughts from your side.
Yeah, just thank you for having me on again. It's good that you've got your voice back, Lani, and I appreciate the space. I think that we need to look at the professional bodies and engaging with them, because a lot of these questions can be answered through your professional representative body, and it's sad at the moment that there's not enough camaraderie or solidarity, and a lot of people are looking at the price of a membership fee, and they're opting not to pay it because of whatever reasons. I mean, money is an issue at the moment with COVID-19, but I think that a lot of this information and peer group solidarity is important, and interprofession solidarity is also important, because if you had to look at physios and bios, our professional bodies are not as big as South African Medical Association. So if we collaborated and we worked together, it would be very powerful in terms of having a voice at the Health Professions Council. Because, and even there, I mean, we've got Lorraine and Aaron on here, and they've done a wonderful job on the PPB board, but they're our peers. We need to support them on the PPB board. And I think that often the professional bodies and the Health Professions Council gets this negative name, but if we are as medical professionals going to go ahead and have more say against, say, the kind of the medical providers, the medical aids, we need to step up collectively. And that's something I think it's fallen on the wayside. We've got a lot of individuals, but not many team players.
Thank you, Neil, and thanks again for joining us 2 weeks in a row now. We really appreciate you setting aside the time. We have run out of time officially, so just a reminder that this webinar, the question and answer document, as well as any other documents, will be available under the webinar tab on the EZMed.solutions website. That's also the place where you can register for all our future webinars that is taking place Thursday afternoons at 4 o'clock. And I'm very happy to announce that next week's will be a very, very interesting one, and I hope to see all of you there. We are privileged enough to have Dr. Quinda from the HPCSA with us next week, and we're going to be in conversation with him. He's obviously the HPCSA acting registrar, as well as CEO, and the HPCSA ombudsman, so it will prove to be a very interesting and enlightening conversation, for sure.
Yeah, it's going to be brilliant. I'm very
You're already preparing for that one.
I'm very excited.
Excellent. So we hope to see you all there. We hope to see you all registering again. And I just wish you all the best. Stay safe, stay healthy, and take care. Good night.